So today, I'm going to answer the question, how are patents misused today in the marketplace? Hi, I'm JD Houvener, owner and founder here at Bold Patents Law Firm. And I've helped inventors, 1,000 or more, with their patent process from research, application development, and now over 500 patents issued. Also the author of Bold Ideas, The Inventor's Guide to Patents. Let's get right to it. How are patents misused? Okay, and usually it's the big guys, right, or the big gals, big companies that misuse patents. And I'll go over the major way they do that first. This is extending the life of a patent beyond the 20 years, right? It's a huge chunk of time, as we talked about in previous videos. That is the lifespan of a patent. Now, they're misused when companies, and usually they're larger, like I said, have licenses that will extend beyond 20 years of the patent. So the license, of course, will include the patented subject matter, whether it's a product, usually it's a software as a service, and it'll be tied or bundled in a package of other, call it technology or technical know-how, also a term of trade secret. That license will get sold or a royalty will be collected when that bundle of rights is then transferred to a client, a B2B, however they're selling that. Sometimes they're sold directly to consumers in the EULA, the end user license agreement. And the subject matter of the patent is being licensed beyond the 20-year limit. So in other words, they're making money on a patent that is now expired. The way they're doing that is by this licensing and tying it to something else, some other condition, some other technology that's being related to their invention. The policy reason why this is not a good thing and why it's generally against the law is that patent rights are supposed to be given to the public. At the 20-year mark, the inventors, the owners of the patent, end, right? That ownership ends, and we all become the bearers of the good fruit of the labor that the inventor brought forward. This is the exchange. This is why we give the incentive to inventors to come forward and share their ideas, because we're going to give them a limited monopoly for the benefit of us all to become smarter. So shame on you companies if you're trying to tie in a license or package deal with your patent to extend the life of it, to monetize, to reap further rewards than you are warranted under the 20 years. Now, patents are also misused in different ways. And I want to bring up patent trolls here, because patent trolls, they get a really bad rap. And I want to be able to explain exactly what it means. A patent troll is a non-practicing entity. It's a company or even an individual that owns at least one patent or a portfolio of patents, and they don't make anything, right? They simply are the owners, and they have the right to prevent anyone else in the marketplace from making, using, selling, or importing their patent or their portfolio of patents into the US at least. And it is their right, it is as the owner of that patent to enforce. As you likely may know, the patent office will not act as police. They will not come after you as the inventor, as an infringer. That's up to you as the inventor to go enforce and police your own rights. And that's all these patent trolls are doing. They get a bad reputation because they really don't make any product or aren't really serving, in other words, a community or impacting the marketplace. They're really only preventing others from making goods or services that might be beneficial to the public. But in essence, the patent itself does generate and increase the level of knowledge in the industry. The area of technology does get smarter because of that information and knowledge gained. The fact that that individual patent owner does not want to commercialize or take it to market themselves should not be seen as a bad thing, although some people believe it to be a misuse of the patent system. So that's sort of what I said, put in quotes, misuse. But those are the two biggies. One, right, companies trying to tie in licensing agreements or other requirements that go beyond the period of 20 years. And then the second one is potentially this sort of policy problem of a patent troll, a non-practicing entity, really not playing ball, not venturing out, being a contributor to the community, to the market. They're more lurking back, waiting for someone to infringe, and then they're enforcing their rights. So hopefully gain some perspective today. Have a good day, everybody. Go big, go bold.